All right, sir. Can you go ahead and give a good introduction of yourself? Who you are, what's your name, where you from, what's your background, what do you do? Let's get to that.
Okay, Ulysses Thomas Ware, go by the name of Thomas. I was a lawyer. I attended State University of New York at Buffalo. I also attended New York University. I became barred in Georgia in 1991. So, I've been in the game a long time.
Mm-hmm.
I had a small law firm in Atlanta, Georgia,
Mm-hmm.
primarily specializing in corporate securities, business law. I did when I first started, I did some criminal cases, general business cases, but my specialty was the investment banking side of law.
Mm-hmm.
Around 2003, had this company called Silver Screen Studio Group, which was a small publicly traded film studio, probably the first in the history of the United States that was at least minority owned. So we took that company from basically zero up to between 40 and $50 million market capitalization. It traded on the what's called a penny stock market
Mm-hmm.
at that time. And I had gotten the company from one of my clients, and he owed us some money, and basically was going to bankrupt the company. But he said, "Hey, look, if you want to take the company over, you can, and try to reorganize it." So I did that, and invested money in it, cleaned it up, and got it operational. Around that time, some previous alleged investors in the company came to me basically like a shakedown.
Mm-hmm.
They're like, hey, look, we see what you're doing with the company. We want between 25 and 30%. We want you just to give us the stock for nothing. I'm like, no way. Lo and behold, they go to a judge in New York, had the judge have the U.S. Marshals in Atlanta raid my office trying to steal stock in the company. That happened on September 1st, 2004. Or marshals showed up in my office with guns drawn. Basically, were going to kill me, murder me, if I didn't give them the stock to the company. They took me in front of a federal judge in Atlanta, Thomas W. Thrash Jr. I think he's retired now or senior status. And basically told me if I didn't put up $250,000 on bail, I had to sit indefinitely, like the judge in the YSL case dealing with Brian Steele. Basically on contempt. They said, well, the judge issued an order in New York ordering you to give these investors the stock. But a judge in New York can't order someone in Georgia to give stock in a company in Georgia. That's clearly outside of the bounds. But nevertheless, I'm in front of this judge. Unless I put up the $250,000, I'm going to have to sit in jail indefinitely, pretty much like Lil Woody. If he didn't testify, he's going to have to sit in jail indefinitely until he purged the contempt. In his case, giving testimony. In my case, would be giving stock to these investors. So that's I guess you could call the analog between myself and the case. And that's why I've been following this case. And I don't know, can you still hear me?
I'm here. Yeah, I'm listening. I'm tapped in fully. Yeah.
Okay. So basically, they indicted me because I got out of jail, posted the money, got out of jail, and I started attacking the case. So and then they found out, okay, look, we can't even do this. So they had the U.S. attorney in New York indict me for criminal contempt in the federal, not state case. It was a federal case
Mm-hmm.
up under the statute, the criminal contempt statute. In federal law is 18 USC 4013. Again, you can pull that up if you want to.
Mm-hmm.
But pretty much it just says that, just like Judge Glanville said, look, you must obey my orders. But in the federal system, it must be a lawful order or an ethical order.
Mm-hmm.
And that's always the implicit within any court order is it must be a lawful order. Because a judge he cannot order you to go say rob McDonald's and bring him the money.
Right.
He may order you to do that, but you don't have to do that because that's not a quote lawful court order.
Mm-hmm.
In this case, giving investors stock that's not even part of the case, like a shakedown, that's not a lawful order. So you don't have to obey that. But nevertheless, I was indicted. I hired this law firm, Garland, Samuel, and Loeb in Atlanta to defend me. They charged me a lot of money and basically didn't do it. As a matter of fact, the guy that's on the Trump case, Manny Arora, I don't know if you're familiar with that case, but it's in the Kenneth Chesebro's lawyer. He was one of the lawyers that represented me. He didn't do it. They worked for the prosecution, made sure I was convicted
Yeah.
in New York.
Hmm.
So they sentenced me to 7 months in federal prison on a criminal contempt charge, whereas in Georgia, I think it was a 20 days the maximum sentence. Prosecutor in my case argued that I was subject to a life sentence. Can you believe that? For
Right.
not quote obeying a unlawful court order, giving these investors the stock. So I've been fighting this case ever since 2003 and on.
Yeah.
Get out of prison in 2019. Since that time, I've been working the case. I filed habeas corpus since they just spinning the case. But one of the issues that did come up, one of the people that testified against me, which again, this didn't come out at trial, went before a judge in an ex parte proceeding
Hmm.
and allegedly entered a rule in the federal system. It's called a Rule 11 plea, which must be done in open court. Must be a transcript, must be records, must be a copy of the plea agreement, must be a transcript of what's called the allocution of this person allegedly pleading guilty, right?
Hmm.
So I go to the court records, custodian of records, there in June of 2023, after the courts opened up after COVID. I spoke to personally spoke to the custodian of records and accessed these records. He personally told me, there was no Rule 11 plea transcripts or anything of anyone ever pleading guilty. In my case, there's no records of this ex parte proceeding that the prosecutor stated in open court this person had pleaded against, just like in the YSL case.
Right.
Secret meeting that they allegedly had in Judge Glanville's chambers. At least there's a transcript.
Right.
In my case, at least I've not been able to obtain a copy of any records at all of this alleged ex parte proceeding of an individual who allegedly pled guilty and implicated me in this quote criminal contempt process. So that was I guess you could say, the analog between my case and the case that's going on in Georgia regarding the ex parte proceedings, a lot of other crooked things that basically went on in my case as well.
So I got a quick question for you. When I was reading through the documentation that you sent me, you said you called the one of those ex parte meetings, and what happened in it a perjury contract.
Right. In other words, if this person who, again, there's no record of the ex parte proceeding in the federal system, the way Rule 11 works is like this. If you're a defendant and you agree to plead guilty to whatever the charges are,
Mm.
if you can pull up Federal Rule of Criminal Procedure, Rule 11,
Okay.
it must be a written plea agreement. And if this person agrees to cooperate, it must enter what's called a USSG 5K.1 cooperation agreement. So you must have that. It must be filed with the clerk of the court, placed on the docket, and that's a public document. That's called a judicial public record. Just like in the Willis case, the order Judge Glanville signed is a judicial public record, which must be placed on the docket, and anyone can pull those documents up, the transcript, the state's immunity order, everything associated with that is judicial. You can't do this in private. So the Rule 11 and the 5K1 contracts, I term those the perjury contracts because this person, there are no records. I have never been able to get a copy of these records, and they're not on the docket. The custodian of record told me he doesn't have them.
Mm-hmm.
So this person that testified definitely lied on the witness stand. So part of his deal was to lie on the witness stand, implicate me. There you go, Rule 11.
Mm-hmm.
But that's civil. Pull up criminal procedure. Get the federal rules of civil procedure.
Give me a second.
Pull up the federal rules of criminal procedure. Yeah, that's the civil rule.
Okay. In the meantime, though, let's backtrack a little bit because when I was reading about what was going on with you, it came up as what they ended up convicting you of was securities fraud. Now,
Right.
can you break that one down?
Yes. Okay. I told you I hired Garland Samuels and Loeb to represent me.
Yeah.
The first case started out as criminal contempt.
Mm-hmm.
It says, look, if you just go ahead and plead guilty to criminal contempt, You won't get any jail time, but they're going to take your bar card. I'm like, no way, I'm going to trial.
Mm-hmm.
They reported back to the U.S. attorney that I intended to go to trial. They came back and indicted me again. This time for securities fraud,
Mm-hmm.
dealing with the same company that I had started, the Silver Screen Studio Group.
Mm-hmm.
So now I have two indictments: the criminal contempt for not giving these investors the stock, and a second indictment of, quote, securities fraud for allegedly making false statements regarding this Silver Screen Studio company.
Mm-hmm.
So they basically bifurcated the case and doubled down because I wouldn't plead guilty to the first case. They brought a second indictment for the securities fraud. So that's Rule 11 that you have up there. Go down to Rule 11C.
C says, let's go to C. B. Okay. All right. C said you can read it. I don't know if you have it up on your end. You can read it on your end, and then the people can see what's going on right now. But C, pretty much in general, an attorney for the government and a defendant's attorney or the defendant, when proceeding pro se, may discuss and reach a plea agreement. The court must not participate in these discussions. If the defendant pleads guilty or nolo contendere, no contest, pretty much, right?
Yes.
To either a charged offense or a lesser or related offense, the plea agreement may specify that an attorney for the government will not bring or will move to dismiss other charges, recommend or agree not to oppose defense. So there's a lot of different
Right.
subsections
But
in there.
basically, right. But the bottom line is it must be in writing.
Yeah.
That's the key. You can't have a oral plea agreement in federal court.
Right.
And there must be a record of this plea, and it must be taken in open court if
Mm-hmm.
there's a guilty plea at all.
Right. 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 Okay. Let's look here. Let's look here because I know the people. I seen somebody ask earlier. So this is what they let me give it to the people real quick. What the original how they were written, not originally because you said it was criminal contempt at first, or was it civil contempt? Which one at first?
Criminal contempt. That was the
Crim-
first case.
Criminal contempt at first, and then they came that didn't work because you were going to fight it, and they didn't like that.
Right.
So then they came back with the securities issue. Now I
Right.
want to I want to understand better about these companies. They said that you were doing this securities fraud through. They named two companies, right?
Right. Group Management Corporation, which that was the predecessor to the Silver Screen Studio. We just changed the name from Group Management to Silver Screen Studio.
Okay,
And there was a
and
second company,
yeah,
Investment Technology Company, which was a client of the law firm.
okay, okay. So you were dealing with pink sheets, right?
Well,
Pink.
well, there was a step ahead of the pink sheets at that time. It was the OTC bulletin board, which was, the pink sheets are the bottom.
Yeah,
And
yeah,
then
yeah,
the
yeah.
bulletin board was, a couple of steps above the pink sheets, but
Okay.
basically penny stocks.
So these were penny stocks in. So what when I was reading a little bit, they were trying to say you essentially did what they call now a rug pull, right? Ran up the price and then sold. That's what they're saying, right?
Well, that's what they allege because that's
Right.
probably one of the easiest charges that you can bring without having to have definitive proof of. In other words, I can say, or the government can say that, or you made a false or misleading statement. Based upon that false or misleading statement, the stock price rose, and based upon the rise in stock price, you sold your stock. Therefore, you, quote, artificially inflated the stock, and therefore we're going to charge you with manipulation, basically market manipulation.
So the person who lied on you, did they lie on you about that what alleged stock manipulation or something else?
But the stock manipulation, the person worked for me. He was a paralegal in my law firm.
Mm.
That when this case started, they took his deposition. They said, "Look, we're going to indict you along with Ware if you don't basically tell us what we want to hear."
Mm-hmm.
He's like, "Look, I wasn't involved in any, or Ware wasn't either. We weren't involved in any market manipulation. This was just how we could." You hear me?
Yeah, yeah, yeah. I'm listening.
Oh, okay. So he denied it, and again, they made he did that in a deposition.
Mm-hmm.
So they indicted him along with me. Says, okay, you're going to go to jail for 20 years as well, unless you implicate Ware in a conspiracy. And that's what he did.
Dang.
He implicated, he said yes, after they put the pressure on him. He was the one that testified against me at trial, saying that, yeah, we were part of a conspiracy. He tried to basically do market manipulation, but yeah, he had previously said until they put the indictment on him, and it's basically a story, his story's flipped.
And he was like the pretty much the main star witness against you, huh?
Absolutely. Yeah. He was the one that allegedly entered the Rule 11 plea, which there's no record of.
Even still to this
Because
day, no record of it.
to this day, there's no record of the Rule 11 plea. And basically, he entered into a cooperation agreement so that he would not have to face any prison time. There's no record of the cooperation agreement either.
Are there records of him being charged?
He was charged in a superseding indictment. About a week later, he allegedly entered the Rule 11 plea, but there's no records of that, which I can send you a copy of the docket sheet and you can see. So I've been arguing with the government, well, the courts, since before I was even left, while I was in prison, but they just basically locked the case. So that anything I submitted to the case, they said, well, it's vexatious, which means, well, you're just harassing me. But the documents I was trying to get would be what's called Brady evidence. You're familiar with the Brady doctrine,
Right,
right?
right.
Exculpatory evidence, where he said there was no conspiracy. He said that not only that, the SEC, which investigates basically market manipulation, they said there was no market manipulation, but they did that as well. So the documents, but again, all of this has come to light after the trial because out of trial, you have to disclose your Brady evidence. The prosecution must disclose all Brady evidence.
Right.
Prosecutor got up in the court and said, no, there is no Brady evidence, Your Honor. So we're giving him everything he's entitled to. The judge went on that, but he had taken the Rule 11 plea, the trial judge. So he hid the fact. If again, if it ever took place at all, he had to disclose that on the record. Yes, this person entered a Rule 11 plea, but that he's dead now.
Right.
But he never disclosed that.
How
Just
did
like
you?
Glanville, Glanville was initially refusing to even acknowledge the ex parte meeting in his chambers.
Right.
In my case, the trial judge allegedly took the Rule 11 plea ex parte because I wasn't there. A lawyer wasn't there. Nobody was there other than allegedly the prosecution, the judge, the defendant, and his lawyer. But again, there are no records of this, just like in the Glanville case.
How did you end up finding out about the plea deal or the ex parte meeting? Let's stick to the ex parte communication. How did you find out about this ex parte meeting?
Because I went to let me see, backing up. I went to the clerk's office in June of 2023. Well, actually, before that, when I was in prison, around 2000 and I think 11 or 12, I wrote a letter to the clerk's office trying to purchase a certified copy of the docket, which again is everything that that went on in the case. So I had the money taken off my prison account. It was like $15 to order the certified copy of the docket. Sent it into the court. I had the records. My counselor sent the check in. And the court, they sent me a copy of the docket, but it wasn't a certified copy with the clerk's seal on it. So I'm like, I wrote the clerk back. I say, look, I paid the money for a certified docket. That's what I want. I don't want a regular, just a regular docket. I want the certified with the clerk's seal on it. Okay. They responded, sent me another, just a regular docket. They would never certify it. I was like, wait a minute, what's going on? If something's wrong, if the clerk won't certify the docket as true and correct.
Right.
But it just, again, no, being a lawyer, I'm like, wait a minute, something's wrong with the docket or something's missing from the docket. So I wrote a magistrate judge in the Southern District of New York, said, hey, look, this person entered a Rule 11 plea on this date. A couple of months go by. He sends me he responded to it saying, hey, send in $45 to the clerks and we'll send you a certified copy and a copy of the Rule 11 plea. I got a copy of the certified docket, but the plea never showed up. And to this day, has never showed up. But I eventually got a certified copy of the docket. And on that docket, everything is in sequence, like 1, 2, 3, 4, 5, 6, etc., on and on and on. But there were 4 out of sequence numbers. It went from like 20, jumped to like 23, jumped from 23 to like 25, 25 to 27. So something's missing. But those numbers they have to be in sequence.
Right.
So I said, wait a minute, what happened? Why are these? I wrote the magistrate judge back and asked him, like, hey, why are these numbers out of sequence? He wrote the trial judge, passed it on to him. He went in and entered an order, what's called a vexatious litigant order, right?
Mm-hmm.
A vexatious litigant order says, hey, you're just harassing the court by asking for these documents. Just like Brian Steele got up and asked Glenville, hey, look, Judge, we understand something happened here
Mm-hmm.
early this morning. And then Glenville just blows up, right?
Right.
Holds Steele in contempt. He didn't hold me in contempt. He just did the sly way of a vexatious litigant order, which means now court doesn't have to look at anything I send in
Mm.
from around 2011, 12 or so, while I'm in prison, which I can't do anything in prison but send it in, via the mail.
Right.
So from 2010 up until I got out, it just would. Sometimes they would send it back. Sometimes they just would, I guess, throw it in the garbage can. Everything I sent into the court because I've discovered either it's a fake Rule 11 or there was never a Rule 11 plea. Which to this day, as of Friday, there's no records of this Rule 11 plea. It's ex parte Rule 11 plea.
Yeah. But no, I want to know originally. Let's go all the way. How did you find out about it at all, though? Because the judge didn't tell you about it, the prosecution didn't tell you about it. Like, who told you that there was an ex parte meeting?
Well, I didn't know until I looked at the document. See, in the federal system, everything that happens just in the state as well,
Mm-hmm.
there has to be a docket in of all the documents in the case.
Yeah.
Now, originally, there was only one docket in the case. Ware and Jones. Everything was on that docket, which again, I don't know this until I get out of prison, but they had a separate secret docket, one for myself and one for this person who allegedly did the Rule 11 plea.
Mm-hmm.
Again, that's illegal, first of all, but I don't even know about it until I'm out of prison. I find this out after COVID because the courts were closed here in, I guess, 2023.
Mm-hmm.
I go to the clerk's office, I log into the computer, I see two cases up under the original docket number. I was like, wow, what is this? So I pulled mine up, nothing on mine. I pulled his up. Then I start seeing what was missing from my docket sheet, these numbers that jump from sequence to sequence, those numbers are on his docket sheet now.
Mm-hmm.
See, showing that on September 22nd, 2006, before a magistrate judge, he entered a Rule 11 plea of guilty
Okay, I see.
to the securities fraud and market manipulation. But again, there's no copy of the Rule 11 plea. It also said he entered into the what's called a USSG. They call it, a snitching document.
Right.
That's what it's known. The USS. You can pull that up. USSG 5K 1.1,
Yeah.
which is the substantial cooperation, which means that if you on the witness stand and testify the way the government wants you to testify, they'll reduce your sentence or not even give you a sentence at all.
In the
And
streets, they call it a 5K1 letter.
right,
That's what they call it in the
5K
streets.
one.
Yeah.
Now, what I also did on that docket, his lawyer, for whatever reason, I don't know if this was, serendipitously or whatever, his lawyer wrote the judge a letter. This is after I'm already in prison. Said, Judge, this guy testified pursuant to a Rule 11 plea, and he also received a 5K1 letter. His lawyer put that in a letter to the judge. I'm like, wow.
Mm-hmm.
So now I got a copy of his lawyer's, which is, again, none of this is on my docket. This is on his separate docket. His lawyer acknowledging that he got the Rule 5K1 letter, snitching letter,
Mm-hmm.
and that the government should basically give him no sentence whatsoever, just basically give him probation, I guess it was. I think it was probation. Because the U.S. Probation Department, when they did this pre-sentence report, was going to put like $600,000. I think it was 397,000 in forfeiture. They wiped all of that out for his cooperation. So that's how I learned about it and verified that he did, in fact, have the Rule 11 as well as the snitching 5K1 letter, which again, there's no copies of. Again, I even filed the Freedom of Information like in 2022, and to this day, they won't even disclose it under the Freedom of Information statutes.
Now there was some, from what I was reading, there was somebody who, so there was two people. You had to pay a fine or pay some money back to the state, and then somebody else. Was that the person that told on you?
Right, Jeremy Jones, he was the quote co-defendant.
Uh, have you ever been able to get back in contact? Can you even talk to him? Is that like witness tampering or witness intimidation or what?
I haven't talked to him. I haven't even tried to talk to him. I tried to talk to his lawyer, but I haven't. Obviously, he's not going to talk to me.
Right, right. That's crazy. So since you, so you actually did end up going to prison for this.
Yes.
Your sentence started when? 2007, 2008? When did it start?
Yeah, it started November 2007.
And then you got released when?
Got released in May 2019, right before COVID.
So why did you end up doing more time than what you were sentenced for?
Okay, this is how they worked that. I told you at first there was the criminal contempt charge, right?
Right.
Then they came with the market manipulation securities fraud charge.
Yeah.
So they went first on the securities fraud charge. That was the first trial. And started January 2007.
Mm-hmm.
Found guilty. Judge gave me 97 months on that case, right?
Mm-hmm.
Then they came like a month later for the criminal contempt charge for not giving, quote, these investors a stop.
Mm-hmm.
Okay, that was a trial as well. They asked me if I would plead out. No. I'm like, look, we got to go to trial. I'm not pleading.
Mm-hmm.
Anyway, went to trial, lost on the criminal contempt charge, right?
Mm-hmm.
Also, they also gave me 97 months, but of those 97 months, 60 were concurrent with the 97 months I got on the securities fraud charge, with an additional 60 months consecutive to the securities fraud charge, which ended up 157 months.
Right.
Oh,
Wow.
so
So that's sick right there. But so when you say they held you in contempt because you wouldn't give these people stock,
right.
how did they word it? Because they couldn't word it like that because that sounds just straight up illegal. So what was the wording that they used?
It, all right, I'm how best to explain this. It, are you familiar with what's called a convertible promissory note?
I've heard of
You,
it, but I don't
you,
know. I couldn't explain it to somebody else.
okay, this is what had happened. This is prior to me even getting involved with the company.
Mm-hmm.
At first, like I say, I represented the company as a client.
Yeah.
Prior to that, allegedly, these investors invested some money into the company, and in return received a convertible promissory note
Okay.
from the company
Mm-hmm.
that allowed, because it traded on the penny stock market, it allowed them, in basically satisfaction of the loan or the investment, to receive stock in the company at a certain price range, say, so to speak,
Right.
which is, again, there's a lot of technical issues with that, but just, in essence, that's what it was. So,
Mm-hmm.
but in order to receive the stock, there's a certain checklist that the investors have to follow, saying that, okay, I certify I'm not trying to take over the company. I certify I have no evil intent for the company. Again, just a checklist that we have to submit to the company in affidavit format. You have to swear to this.
Mm-hmm.
They actually sent that to me. I said, okay, look, I will give you the stock, but you must follow the law. You got to go through the checklist. Send me a sworn affidavit. I'll have your lawyer do that. And if you meet the criteria for the stock, I have no problem. I'll issue the stock. They would never do that. So I was like, okay, just like the clerk would never certify the docket sheet. So I'm like, wait a minute. If you claim you're entitled to the stock, just follow the requirements to get the stock, which must be a sworn affidavit following these 5 steps. They would never do that.
Mm-hmm.
I'm like, okay, that's got to be something. There's got to be something wrong, because a lawyer would sign off. So first they just sent me a letter that says, yeah, we are qualified for the stock. I'm like, no, you got to send an affidavit. Say you got to swear to it. Then they come back and say, no, we don't have to swear to it. They go to the judge in New York. He said, yeah, you got to swear to it. And they sent me another letter saying, no, basically, long story short, is that they would never swear to the conditions, what's called Rule 144K. You can pull that up if you want to.
Mm-hmm.
in order to convert the stock from the convertible promissory note into basically free trading stock. But because, again, some other technicalities, which they never satisfied, was the reason the stock never was issued. At least there was no reason for me to issue bogus Rule 144K, what's called opinion letters that would authorize what's called an unregistered public offer of the securities of the stock, which is in and of itself made the quote order from New York unlawful because a lawyer doesn't have to sign off on bogus exemptions to the federal security laws. That's the technicalities of it.
So essentially, they were claiming to be investors via the previous owners.
Correct.
They didn't get their well. They didn't uh, cash. I will just use some common terms. They didn't cash in on it with the previous owner, but when they sold it to you or passed it off to you because they owed debt, then they tried to cash in under you or through you.
Correct. Right. Absolutely. Once they saw me and the team turned the company around, they saw the stock was going again. It increased the tremendous value from basically nothing
Right.
to between 40 to 50 million or so, give or take.
Now, why were you and the paralegal the only one charged? You had a team. I'm assuming. I know you worked at a law firm that had multiple people. I seen at
Right.
least multiple names as if they were partners, right? At
Right.
the law
But
firm.
they just charged me and him because they wanted to charge. I mean, I don't honestly why they chose me to charge because I mean it was a racial thing. It was black. I'm black.
Yeah.
These alleged investors, Jewish investors out of New York.
Mm-hmm.
So the judge is similarly situated.
Right.
So they like, look, we could just pressure him.
Right.
All of them went to Harvard Law School. So the judge that even arrested me in all these people sort of like a little clique.
Right.
And they just saw, look, we can railroad him right on out the way, and which is pretty much what they did. Now, again, I hired Ed Garland. I don't know if you're familiar with Ed, the Garland law firm in Atlanta.
Right.
Ed Garland, Don Samuels, and Manny O'Rourke. I hired the firm. I paid them a lot of money to. I said, look, I'm not pleading guilty. He offered me a plea. I refused to take the plea.
Mm-hmm.
I'm like, okay, I'm going to trial. He's like, oh, no problem, slam dunk case. There's no way they can win this case.
Right.
He called me into his office not shortly, shortly before we was go to trial. He's telling me he wants me to plead guilty now. He doesn't think we can win the case in New York. Matter of fact, he doesn't even want to try the case now. After I done paid him all the money for a trial,
Right.
he's telling me to plead guilty. I'm like, there's no way I'm pleading guilty to this.
Hmm.
So had to end up firing them. Basically, I tried the case pro se myself.
Yeah.
I mean, I had spent a lot of money on the case, so I was just like, well, I'm just throwing good money after bad.
Right.
So I tried the case myself in New York.
Man, this is an unfortunate situation. So with this film studio you had, and it was in Atlanta, right?
Yes, yes.
How did you end up building value in that studio?
Again, this is like 2003. Now, this is before Netflix. This is before YouTube. This is before any of the stuff that we're doing now.
Right.
This was basically the first generation of digital film.
Mm-hmm.
Because I've been practicing law since uh, 2001, so I had quite a bit of capital. So I just leave it at that. I had made a lot of money practicing law, so I bought all the equipment. I rented a studio up in Norcross. We had an 8,000 square foot actual building that was the studio for the company. But anyway, we're making small independent films.
Mm-hmm.
Basically, again, this is before Netflix. This is before YouTube. This is before social media. This is before any of the stuff that people take for granted. Now, this is even before digital cameras. We had one of the first digital cameras in the market at that time. But
Mm-hmm.
anyway, I saw the market going to what it is now. I saw this in 20, 2002, 2003. That hey, look, this is going to be the future of entertainment, content creation. I saw it
Mm-hmm.
in 2002, 2003. So I wanted to get in early.
Mm-hmm.
Yeah, it was a small company, but the value was the potential. Other people saw the value. Again, this is before any of the stuff that you take for people take for granted now. YouTube.
Right.
Instagram, social media. There was no iPhone in 2002. If you
Right.
look back, there was none of the stuff people, will basically go crazy if they don't have now. None of that existed in 2003. But
Mm-hmm.
because I have a technical background, my background is in electrical engineering
Mm-hmm.
and communication systems. So just being technically savvy, I said, okay, I can see this technology wave coming. I want to get it on the ground floor,
Mm-hmm.
which is what basically what we did. We got it on the ground floor, set up the infrastructure to generate massive content on a worldwide scale.
Mm-hmm.
Again, even in like 2002, 2003, 2004, that was growing.
Mm-hmm.
But had that company stayed in business and not, basically been interrupted, would easily be $1 billion company now, easily.
Yeah.
I mean, it would have been bigger than Tyler Perry. This was before Tyler Perry came out with his first movie
Mm-hmm.
in his studios and so forth. So we were there right at the beginning of the digital wave. So, but it just got interrupted.
So essentially, they were able to. They wanted to shake you down, right? You weren't going
Yeah.
for it, but they were able to, I guess, from their perspective, capitalize on the fact that you had sold a nice chunk of stock.
Yeah, I mean, the company was doing well. Again, potentially. It's just like okay, the number one thing now is artificial intelligence.
Right.
You got open AI, you got these other companies coming up with the chatbot, GPT, et cetera, et cetera.
Mm-hmm.
None of those companies are actually making a profit now, but they see the potential
Of
of
course.
artificial intelligence.
Yeah.
That's where the profit. Now, these companies are $1 billion companies now, based on an idea of the potential.
Right.
Back then, it was millions, now it's billions. But again, all of these companies aren't going to make it. It's going to probably be 4 or 5 companies that make it. The rest are going to just fall by the wayside. But the 4 or 5 or 6 or whatever that make it, they're going to be worth hundreds of billions of dollars because of the potential
Mm-hmm.
of artificial intelligence. So an investor getting in now at the ground floor of artificial intelligence, you may put in 100,000, a million, or whatever your investment is, and if that hits, that investment will be worth billions probably in the next 5, 10 years, or whatever.
Yeah.
It was
I'm in these spaces too, so I'm interested in it. So I do have questions because it is very interesting story. So the company was worth between let's say between 30 to 50 million dollars. It was in there somewhere, right?
right.
You, I would say, it's a nice chunk of change, but relatively, what you sold wasn't that big of a chunk, right? They say you sold
No,
something around $200,000 worth of stock or something like that, right?
give or take, yeah.
Yeah. So where was the rest of the ownership? Did you own the rest of it, or who else owned? Or I guess what are other major investors? Who else owned the major pieces? Was it all you
Okay,
or
but
what?
now, okay, a penny stock company is not like a NASDAQ or a Dow stock. You don't have big institutional investment. Matter of fact, institutions can't even invest
No, yeah, no, I
in.
don't mean institutional, but I mean, let's just say uh, there was 50 million shares. Did you own 49 million of them, or was there like did one of your
No.
partners own 20? That's what I mean. Was there other anybody else like you that owned millions of shares of this penny stock or
Okay, all total, there were over 3,000 shareholders in the company.
okay,
I didn't know all 3,000, but there
right,
were again people buying and sell every day, so you don't know who's buying and who's selling. But of the what's called insiders or people that own more than 4.9%, there were probably myself and I won't say less than 10 other people that own more than 4.9%, which
okay,
you have to file disclosures, indicating how much of that stock that you own. So major shareholders less than 10, but all total there were over 3,000 people as
okay.
shareholder investors in the company.
And were they so they were only investors? They weren't people who handle any of the day to day to keep the business going while you were away, pretty much.
Yeah, that's right. They just invest. Just like if you bought shares in
Right.
Apple Computer, you can buy and sell the stock, but you don't know what's going on
Right, right, right.
internally at Apple. Apple, you're just an investor. You buy, sell. Apple, they have no idea who you are. Things again, same concept. I had no idea who these 3,000 people were,
So you
but they
came in
were.
you came into ownership, but then you ended up being like an operations. You started to manage the business, operate the business.
I was CEO after I cleaned it up and got it basically functional. I was the CEO of the company.
And when the feds came, did they pretty much force you to shut it down, or was it just you couldn't get anybody to continue working while you went through that?
They didn't force me to shut it down, but what they did was they issued what's called a suspension order
Mm-hmm.
on the trading of the stock, saying basically we believe the stock is being manipulated.
Uh,
Therefore, basically, investors be cautious. In other words, then they allowed it to start trading again. But once you get that market manipulation tag on you, it's
mm-hmm.
pretty much over with you. At that point.
Right,
So
right.
the company continued to operate, but I mean, the handwriting was on the wall at that point.
Yeah. Okay, so at the point that you are at now, what can is there anything that anybody could do to help, or or is just people knowing about it enough, or can anybody do anything?
Oh, no, the documents I sent to you, those documents, the cases, I'm fighting the case now. The case is ongoing right now in the U.S. Second Circuit Court of Appeals
Mm-hmm.
here in New York.
Right.
I filed in 2022 what's called a writ of habeas corpus. I don't know if you're familiar with a writ of habeas corpus,
I'm
but
familiar. Yep.
yeah, one of the grounds of habeas that you can obtain relief after conviction is what's called actual innocence.
Mm-hmm.
Actual innocence for the purpose of habeas corpus is that when you find newly disclosed Brady exculpatory evidence, which the prosecution suppressed prior to trial, is a valid ground to seek habeas corpus relief,
Mm-hmm.
which I've found. Actual innocence, Brady exculpatory evidence, which would be the Rule 11 plea, 5K snitch letter, and some other documents that the government didn't disclose prior to trial, which I use that as the grounds for the habeas corpus petition, which I filed 2022.
Mm-hmm.
Now, I told the judge it goes back to, it should go to an independent judge, just like the Glanville recusal motion.
Right.
He wants to take the motion and basically decide his own recusal, but the Georgia Supreme Court says no, they have to go to an independent judge.
Mm-hmm.
And even it has to go to probably an independent judge outside of Fulton County because, again, the appearance of a conflict of interest.
Right.
But now, the trial judge on this particular case is dead now. He died in 2021.
Mm.
So they appointed a new judge after I filed the habeas corpus petition. The
Yeah.
new judge allegedly, he wasn't involved in the trial at all. He's a new judge. But anyway, went to him first. In a habeas corpus petition, the government is required to what's called show cause as to why this petitioner should be denied or granted relief within 3 days of filing the habeas corpus petition and the government being served, right?
Mm-hmm.
To this date, the court refuses to serve the government with the petition.
Mm-hmm.
That's been over 2.5 years.
Wow.
The new judge he just won't serve the government with us. So I've gone through every procedural, just like in the YSL case. Initially, Glanville said, "Hey, look, I'm not giving you the transcripts." Then he said, "Well, I'm gonna give it to you, but I'm gonna redact it." Then he finally, uh, released the transcript, allegedly the total transcript and so forth.
Mm-hmm.
It's the same way with this judge. He's like, again, I've filed everything that you can file, but he just won't serve the government with the petition,
Mm.
which is a problem in and of itself. Why? It comes down like, why would Glanville hold an ex parte proceeding? Why would you try to hide the transcript
Mm-hmm.
of the ex parte proceeding? Why would you not inform the defense of the ex parte proceeding? Likewise, with that, in this case, a habeas proceeding, why did you not order the government to be served? Even if he didn't order the government to be served, out of the government's duty of candor, they should respond to the habeas petition anyway, just out of, again, duty of candor to the court,
Right.
admit or deny the allegations in the habeas petition. So they just spinning it. That's that's the biggest small of it at this point. But I'm continue to press it.
Yeah. So you never lived in New York? Then they just took the case up there because that's where the investors were at.
I went to school up here. I went to New
Oh
York
yeah,
University Law School.
you did say that.
Plus, I did business back and forth. Again, I told you I got barred in 1991, so you're talking over 30 years back and forth. I did business all over the world, but did a lot of business on Wall Street. Just again, But the case was in New York
Right.
because of the investors were here in New York.
Okay. So, man, I don't know if this is too much, but so how have you been able to maintain yourself and sustain life after prison? Then,
That's a good question. Like I say, I've been in law a long time.
right.
So even before this case, which happened in 2007. So between 2000, well, between 2000 and 2007, like I said, I did okay for his capital. So
Right.
I mean, plus I know a lot of people. I know a lot of people for his investors. With millions, if not billions of dollars. So